Well, ladies and gentlemen, welcome to part two of our discussion of Justice Scalia's legacy. We have a remarkable group here, and I will briefly introduce them again. Rick Hasen is Chancellor Professor of Law and Political Science at the University of California at Irvine. He is the author of the forthcoming book, The Justice of Contradictions, Antonin Scalia and the Politics of Disruption. It is not out yet, but it's out on March 20th, and you can get a 25% off coupon, which should be lurking about in the back, for this wonderful book, which I'm sure you'll want to get after you hear from Rick. Elizabeth Wydra, great friend and colleague of the National Constitution Center, is president of the Constitutional Accountability Center, where she also served as chief counsel. She has been recognized as an exemplary legal writer by the Green Bag Almanac. She's a constant commentator on television and radio, and the Constitutional Accountability Center is this very important organization that I want you all to know about that files briefs and makes arguments suggesting that Justice Scalia's methodology, namely textualism and originalism, can lead to progressive, not only conservative results. So her perspective is uniquely valuable, as always, to tonight's discussion. And finally, Kannon Shanmugam is a partner at Williams & Connolly, where he heads their Supreme Court and appellate litigation practice. He is widely recognized as one of America's premier appellate advocates. He has argued 21 cases before the Supreme Court, and I think he has some coming up. And he served as a law clerk to Justice Scalia. Please join me in welcoming Rick, Elizabeth, and Kannon. Rick, in this extremely interesting and provocative and illuminating book, you take a view of Justice Scalia that differs in some ways from the one that we just heard from Ed Whelan. You talk about the caricatures of him on the left and the right and say neither caricature is fair. Justice Scalia was full of contradictions. Give the audience a sense of those contradictions and what you think his legacy on American law will be.
Sure. Thank you for the opportunity to be here. I appreciate it. And I want to preface what I say by saying that this is not a biography of the justice. It's not a collection of his speeches. I never met the justice in person. It's a look at his legacy. You can think of it as a biography of his ideas or of a talk about his influence on the court. I have no doubt that he was a patriot, a great family man, a good friend to many people. And in fact, in my preface, I say, if you want to get a sense of the man, you should read Cannon's tribute to him that was published soon after his death. And I would have said also to read the collection of speeches, but that came out after my book was already in press. So I have to put it in that context. But I do think that he was a justice of contradictions because primarily he presented his jurisprudential approach, which we've talked about, the approach of originalism, which tries to find original public meaning to understand what the Constitution means, and textualism, which was a kind of a parallel but somewhat different way of reading texts, reading statutes, in order to understand what the words would mean to an ordinary reader at the time that a statute was passed. He presented these as totally neutral ways of deciding cases, and in fact, as Ed suggested in the last panel, that the Constitution requires justices to read cases this way. He took the view that this was the only way that was legitimate to read cases, yet in many cases he either found some other principle that would trump originalism or textualism, or he ignored originalist or textualist ways to get to a result that was often, although not always, a conservative result. And so I think, like every other justice, and I'm not saying he was different than any other justice on the court, like any other justice, what he did was a mix of looking at text and history and taking his own values to understand what the law should be. What was different about Justice Scalia is that he held himself and everyone else to a higher standard and said that he could accomplish this. I'll mention one other way that he was full of contradictions. The justice would lament the coarseness of society and the decline of civility, and some of that comes across in some of the speeches in his book. And yet, by my measure, and I actually have a chart in the book, looking at how often his opinions were described as sarcastic or caustic, he was off the charts. He was the most sarcastic justice by orders of magnitude compared to anyone else. And in fact, in the same-sex marriage case, the Obergefell case, one of the last cases that Justice Scalia wrote a dissent in, one of the last major cases, he wrote that the opinion was, if he had to sign an opinion that included language that Justice Kennedy included, he would hide his head in a bag. And he said that it had the wisdom of the aphorism of a fortune cookie. He said that the opinion was as pretentious as the ideas behind it were egotistical. So he was the nastiest justice by far, and I think he created a lot of coarseness at the same time that he complained that the judiciary and society as a whole was too coarse. So he was full of many contradictions in terms of how he decided cases and also how he presented himself as a public figure, which he was.
So two powerful criticisms. The first, that he had an originalist methodology, but in many cases he was inconsistent to it and changed his methodology based on the preferred results. And the second is that he coarsened our discourse. Elizabeth, I think you share both of those criticisms. Why don't we begin with the second, and then we'll get into the jurisprudence later. In what ways do you think Justice Scalia coarsened discourse, and other particular opinions that you find especially upsetting in its rhetorical tone?
Yeah, I think, we often think of Scalia as a colorful writer, and he certainly was that, even in these instances where he was taking shots at his colleagues. But I think what strikes me in terms of problematic rhetoric is not necessarily the rhetoric aimed at his colleagues, but the way that some of his writing about people affected people. I had the honor of being part of the litigation effort to vindicate the constitutional principle of marriage equality, and I know for a fact that a lot of law students and lawyers, reading the way that he wrote about intimacy between gay and lesbian couples, were deeply hurt by that. Comparing the intimate acts between loving couples who happen to be gay or lesbian, analogizing that to murder, to bestiality. To have a justice of the Supreme Court say that about you is deeply hurtful. And there is a way of describing it, which Ed did, about, this should be something that the states can decide. And we saw a little bit of that in Chief Justice Roberts' dissent in Obergefell. But that's not how Scalia wrote about it. And so, I think for a lot of people, when you hear this evocation of Washington's beautiful words that bigotry will have no sanction in this country, it's difficult to square that with a lot of what some of us would see as the bigoted words that Scalia wrote. And he would try to get away from it by saying, I'm not saying anything bad about the individuals, it's just the conduct. But that doesn't really fly. People tried to make that argument. How could you apply that to interracial couples? I have nothing against people of color or white people, but you just can't get married. It's the same thing when the conduct is so integral to the right being asserted. It is very difficult to not take that as an animus against you as a person, which is not just, I think, contrary to a lot of the moral principles that he espoused, and certainly trying to ally himself with President Washington's words in that particular instance about not giving bigotry sanction in this country and not merely tolerating people, that's problematic. But I think it's also, getting to Rick's first criticism, not an accurate application of the Constitution and the sweeping guarantees of equality for all persons that are in that document.
Kannon, there's no doubt that Justice Scalia's colleagues sometimes smarted at his rhetoric. When he said that Justice O'Connor's opinions couldn't be taken seriously, she famously retorted, "Sticks and stones may break my bones. That's probably not true." And even his friend Justice Ginsburg said publicly that she thought sometimes his sharp pen might have made it difficult for him to win friends. On the other hand, many of the examples that Rick just gave came from Justice Scalia's later years. Do you think he became more sort of unguarded, intemperate as he became older, and is it not fair to say that he was intemperate for much of his career?
Yeah, so let me tackle that first. Let me say how great it is to be here at the National Constitution Center. And Jeff, thank you for including me, and it's great to see so many of you here on this rainy night. I guess you're all here to warm up for the Eagles victory parade tomorrow. And I want to say a particular hello to my children who I think are watching on the internet in equally rainy Washington tonight. I do want to tackle this issue because I think in many ways, to my mind, this is the most serious criticism that is levied at Justice Scalia, that the tone of his opinions was intemperate, that had an effect on the legal community and society at large. And let me offer the defense that I think Justice Scalia would offer if he were able to be sitting here today. I think Justice Scalia felt quite profoundly that when you are in the arena of legal opinion writing in particular, the other side's ideas are fair game, and you can attack them in as colorful or trenchant terms as you can manage in an effort to illustrate their deficiencies. And Justice Scalia, I believe in his interview with, I think it was Leslie Stahl on 60 Minutes, said that he attacked ideas and not people. Now, one can debate whether he crossed that line in particular instances, but I think that was very much his view of what he was doing in some of his most contentious opinions. And I think what actually bothered Justice Scalia was not so much that opinions came out with a result that he did not like, though that was certainly true in many of the most high-profile cases where he found himself in dissent. What really bothered him was what he perceived to be a lack of legal reasoning, a lack of logic. That was really, I think, what bothered him the most about the Obergefell opinion. When he was criticizing Justice Kennedy for descending from the level of Justice Story to the aphorisms of the fortune cookie, I think what he found most problematic about that opinion was the ratio, as he would have thought of it, of rhetoric to rigorous, logical, legal reasoning. And that really bothered him with Justice O'Connor's jurisprudence, because Justice O'Connor was the master of the amorphous balancing test. And it really bothered him with Justice Kennedy's reasoning, particularly in certain areas of the law. Now, I've heard it said by some of his critics who typically come from the left that the tone of his opinions had a negative effect on the legal community. I have to say that from my perspective as a practicing lawyer, I have not seen that. I have not seen a marked change in the tone of legal writing. If anything, I think what we have seen is an effort by other members of the Supreme Court, both from the jurisprudential left and the jurisprudential right, to write more like Justice Scalia in the sense of writing in vivid terms, in terms that ordinary readers can understand. And I think in many ways, again, if you look across the jurisprudential spectrum, you see members of the court like Justice Kagan, who I think are very much heirs to Justice Scalia's style of writing. So I would think that to the extent that he has a legacy as a legal writer, it is in the vividness and the persuasiveness of his prose, and not in perhaps his style of criticizing colleagues.
Thank you for that defense, and let's take that up, Rick. You, at the end of your book, suggest that Justice Scalia's influence will be limited, that essentially his vision of vigorous originalism may find few acolytes, and that his tone may be alienated. But Kannon has suggested the opposite, that Justice Kagan, in her colloquial writing, you think of vivid phrases where she begins that campaign finance decision saying, imagine you're an Arizona legislator. And it's a Scalia-like phrase, and she praised Justice Scalia at Harvard Law School for doing more to transform the terms of debate in American law than anyone else in the 20th centuries. And then we have Justice Gorsuch, who also writes very vividly and calls himself an originalist in the Scalian style. So why do you believe that Justice Scalia's influence will be limited rather than lasting?
Well, let me first respond to just a little bit of disagreement. I think Justice Kagan, like Justice Scalia, is one of the best writers on the court, and I enjoy reading her opinions. But there's a sharpness to her, too, and I think that Scalia paved the way. I'm not sure if we're talking about the same Arizona opinion, but in the Arizona campaign finance case, the majority opinion by Chief Justice Roberts talks about how this campaign finance law might have been passed to promote political equality, which the majority says is improper, and he found a smoking gun, he says, on the website. And Justice Kagan's response is, well, there's certainly smoke here that the majority finds, but it's the kind that goes with mirrors. And I really thought that that was Scalia-esque and uncalled for. And as much as I admire Justice Kagan's writing generally, I think it has a sharpness. And I give other examples of the book of Justice Alito doing this. Certainly Justice Gorsuch, at some of some of the early cases, he says something like, at the oral arguments in the Wisconsin, political gerrymandering case, he says, can we get back to this arcane matter called the Constitution? So and he said in another opinion that came out at the end last year, if there's a problem with the statute, there's a way to fix it. It's called legislation. And so I definitely sense a difference in tone, which I think of as inappropriate, and I think it spreads throughout the system. So I disagree with Kannon. I am seeing it, and I do believe that Scalia paved the way. On the question of Scalia's legacy, what I say is that I think there's going to be, and we're already seeing this, a kind of division or bifurcation. I call him a polarizing justice in polarizing times. It's the first line of my book. And I think Ed Whelan coming here and the great sales that the Scalia Speaks book has had has shown that for some on the right, he has become a kind of icon, a deity. And it's the same thing that's happened with Justice Ginsburg on the left. One of the things I talk about is we now have these celebrity justices who are public personas, who are out there giving speeches, selling books, doing exercise programs. You know, you can get a book, or you can learn about the Ruth Bader Ginsburg workouts. You can, be as fit as she is.
That's not really her fault, though.
Well, she, I think she cooperated with that, and with the, the notorious.
She's being nice to her trainer.
Okay, well, in any case, I think what's happening is that the court is becoming more polarized. I think if you look at the court today, if you want to figure out how a justice is going to vote, it's not whether they follow originalism or textualism. It's whether they were appointed by a Democratic president or a Republican president. It's completely ideologically polarized. And so I think Scalia will be viewed as a product of the polarized times. Some will love him and some will hate him. What will be left, I think his biggest legacy, and we could maybe get into this later, is at least in non-controversial cases, his views of how to read statutes is the thing that's likely to be the most enduring. Justice Kagan was famous for saying, we are all textualists now. I don't believe it in the hard cases, but I think in the easy cases, he's definitely changed things there.
Well, Elizabeth, on the originalism point, your wonderful organization was established to fight Justice Scalia and other originalists on their own terms and to make honest arguments about text and history that you believe should lead to progressive results. In that sense, do you agree with Justice Kagan that Justice Scalia changed the terms of debate, and in that sense, will his influence live on?
Yeah, absolutely. And I was reminded coming here that my colleague Brianne Gorod and I wrote a piece for the wonderful blog of the National Constitution Center after Scalia's passing about how his legacy might be more liberal than he would expect, or might be a surprising aspect of his legacy, precisely because I do think he forced progressives to argue on the terms of the meaning of the Constitution itself. And the Constitutional Accountability Center certainly had taken up that challenge and said, actually, if you look at the text and history, in addition to the values of the Constitution, particularly the Constitution as amended over time to make it more equal and more inclusive, more democratic, that often led to progressive results. And we tried to hold, I guess as our name would suggest, justices like Scalia who professed to be textualists and originalists to that meaning. And sometimes I think he lived up to that, and sometimes I think he didn't. I think I do not think he took the 14th Amendment's guarantee of equal protection as seriously as a true originalist would, because that was a sweeping change to our Constitution. It wrote into, for the first time, the Constitution, the Declaration's principles of equality for all people. And I don't think that he fully grappled with that. I think that's why, if you looked at affirmative action, for example, the drafters of the 14th Amendment's Equal Protection Clause had very forward-looking, race-conscious programs that could be seen as the original affirmative action programs. And for him to never even grapple with that, I think, is just one blind spot in his originalism. But I think that when you look at the way that progressives have responded to that, Justice Ginsburg has called herself an originalist, Justice Sotomayor has suggested that as well, in addition to Justice Kagan's line about we're all textualists now. They have taken up the challenge of proving that the Constitution's text and history actually do support voting rights. Justice Ginsburg wrote a wonderful majority opinion in Evenwell that was a very text and history focused opinion. Her dissent in Shelby County versus Holder was very rooted in text and history. We've seen Justice Sotomayor as well bring that in, and Justice Kagan, I think, in her statutory interpretation, has been very textualist as well. And so I think that that is something that is a substantial legacy of his that I see as a positive, because we are taking up that challenge, and wonderful scholars like Atil Amar and Jack Balkin and Jim Ryan have really built the scholarship behind, frankly, proving Justice Scalia wrong about a lot of the things he said about the Constitution, if you do take original text and public meaning seriously.
Great. Well, we'll dig into some of those areas that you just mentioned in a moment. But Kannon, tell us about the debate within the conservative legal movement between Scalia-like originalism and other approaches. Justice Alito and Chief Justice Roberts are not originalists self-consciously and don't evoke history and text as self-consciously as Justice Scalia did, and yet Justice Gorsuch absolutely is. So if President Trump gets future appointments, are they likely to be Scalia-like originalists, or might they come from a different strain of conservatism?
Sure, so I'll try to do what any Supreme Court advocate is taught to do, which is to not only answer your question, but to respond to some of the things that have been said already.
Of course. They're more important than my question.
I do think that Justice Scalia will be remembered really as the leading legal figure of his generation and the most influential justice of his generation, and likely as one of the most influential associate justices, that is to say, justices who did not serve as Chief Justice, in the history of the court. And that is because he really did change the terms of debate on both of the major tasks of the Supreme Court, on constitutional interpretation with his originalist view about which we've heard so much already this evening, and on statutory interpretation with his devotion to statutory text, as Rick mentioned. I was reminded of this just this morning. I'm preparing for an argument that I'm going to give in the court in a couple of weeks, and the two leading Supreme Court cases on this question of statutory interpretation were written in 1974 by Justice White, who wrote the majority opinions in both cases. And to read those opinions, they really bear no resemblance to what the Supreme Court does today. Whether it's an opinion by Justice Thomas or Justice Sotomayor, when the Supreme Court tackles a statute, it starts with the text of the statute. And yes, there are variations, and variations even within the quote-unquote conservative members of the court on the extent to which they are willing to deviate from the text. But ultimately, everyone is playing more or less on the field that Justice Scalia established. And I think in many ways, the best evidence of that is sitting up on the stage with me, in that Elizabeth is here as a liberal who nevertheless is fighting for her causes within the methodology established by Justice Scalia. I will say, to answer your specific question about the conservative legal community, that there are fault lines, just as there are fault lines within the liberal or progressive legal community. And the two fault lines I would identify are, first, that there are some Republican appointees on the Supreme Court who are willing to look to legislative history, who are not complete devotees of the Scalia methodology, like the Chief Justice and Justice Alito. And second, there are some members of the conservative 5 members of the court, just as I suspect that there are some members of the Democratic group on the court who are more devoted or less devoted to stare decisis, the idea that even if you think that a precedent is incorrect, it should nevertheless be followed absent exceptional circumstances. I think Justice Scalia, by his own admission, was much more of a devotee to stare decisis than Justice Thomas. His frequent but not uniform a bedfellow in constitutional cases. And there are some fault lines, and I think that those fault lines become particularly pronounced on the Supreme Court when you have a slim majority in a particular area of the law. When cases are being decided by 5-4 majorities, as cases are on most of the major issues of the day, seemingly nowadays, you see those disagreements in methodology coming to the fore. And I think it's very hard to predict how and where any future nominees by President Trump will fall on those spectrums. I want to say just one last thing in response to something that Rick said. Rick described Justice Scalia as a polarizing justice in a polarizing time. I think what Justice Scalia would say in response to that is that, yes, we do live in an increasingly polarized time. I think Justice Scalia would bemoan that in many ways because, as Ed very eloquently talked about in the last panel, Justice Scalia was somebody who very much believed in the idea that you fight like it's going out of style when you're writing opinions and when you're in the courtroom, but then you go out for a drink afterwards. And I think his friendship with Justice Ginsburg really reflected that mentality. At the same time, I think with regard to the judicial confirmation process and the role of the judiciary in particular, Justice Scalia's view was that the very reason that we have descended into rancor in the judicial confirmation process is precisely because you have a Supreme Court that plays an activist role. And by that, what I mean is a Supreme Court that is really unwilling to leave to the democratic processes the big issues of the day, which creates a tremendous incentive on the part of presidents to nominate individuals whose votes can be predicted ex ante on those issues, and it injects an enormous amount of rancor into the actual confirmation process. And as early as his dissenting opinion in Casey, Justice Scalia bemoaned that, and I can assure you that in private conversations, Justice Scalia was really concerned about that. At his heart, Justice Scalia was very much a judicial minimalist. He had great faith in the political branches, even when he thought that many of the people who populated those branches were a bunch of yahoos.
I just wanted to add one thing on the nomination process. I think that, as Rick mentioned, we do have sort of these two archetypes, I think, on both the left and the right of kind of the iconic justice. And so whether or not the person actually is in the mold of Scalia, I think that we will hear that because it's a recognizable name. When most folks can't name who's on the Supreme Court, I think, if you talk to conservative voters, they've heard about Justice Scalia and have an idea that they like him. And so I think even if you're not someone like Justice Gorsuch, who explicitly styled himself like Scalia, we're going to hear people claim to be in that mold. When I go on Fox News to debate, they don't even really think of Chief Justice Roberts as a conservative justice, which I think is funny because he is. But no one's going to say we need another Chief Justice Roberts from President Trump. They're going to say we need another Justice Scalia.
Absolutely so. Okay, now it's time to wonk out a bit, but let's do so in a way that our audience will connect to and learn from. You've heard, friends, about statutory interpretation. So we're talking about two different things. When the judges interpret a statute or a law passed by Congress, they have to decide what the text of that law means. And when they interpret the Constitution, they have to decide if the law passed by Congress is consistent with the Constitution or not. So we're going to talk about statutory interpretation. And Rick, you suggest that Justice Scalia's methodology, which was purportedly refused to consult legislative history, namely the intentions of the Congress people and their staff who drafted the law, far from constraining judges, as Justice Scalia claimed, actually left them free to insert their own policy preferences into laws. So unpack for the audience what Justice Scalia's philosophy was about legislative history, why it was important, and why you think he betrayed it.
So Justice Scalia, when he would interpret a statute, would say, don't look at legislative history, it's self-serving, It's not the law. Congress doesn't pass a committee report or a statement that a senator makes on the floor. And it's unreliable. He quoted another judge who said it's like going to a party and looking over the crowd and picking out your friends, that you could pick and choose. And so what he proposed instead is that you figure out what the words of the statute would have meant to an ordinary speaker of the English language at the time the statute is passed. This is somewhat different than originalism, where at least sometimes, but not always, Scalia would go beyond the text of the statute and look at how it was understood in the context of the time, the original public meaning. And so then you have to have some kind of social construct. He didn't do that with statutes the way he did it with, and it's an interesting question which I explore in the book. Why does he have these different approaches? But textualism, instead of looking over the crowd to find your friends among the legislative history, lets you do things like dictionary shopping. Oh, I found this dictionary. You'd think I'm kidding. Some Supreme Court opinions were, well, the third meaning of this word says this, and I found a better dictionary. This is a better dictionary to use because this is closer to the time, and the fourth definition says this. Or Justice Scalia was willing to go along. He said he was reluctant, but he used all the time so-called canons of construction. For example, a rule that you should interpret a criminal statute in a way that would have some more leniency towards criminal defendants. Thumbs on the scale, he called them, but yet he used them. And given the nature of trying to figure out words in context, linguists, who I quote in the book, say that it's really much more like a parlor game. I'll give an example not of a Scalia opinion, but of an opinion by Judge Easterbrook, who's another one of these textualist judges, who was deciding whether someone would get 10 years more in prison for selling LSD on blotter paper. The LSD would be put onto some paper and it would be sold on little sheets of paper. And the question was, do you weigh the paper? Because the amount of time you spend in jail depends on the weight of 10 more years in jail because he put it on paper rather than selling it in its pure form. And he said, the piece of paper is a mixture of drug and paper. And he said, that's common, ordinary parlance. No, it's not. It's a parlor game. And I think a lot of what textualism is using dictionaries and using word games, what Justice Gorsuch calls plain old-fashioned grammar, to actually reach results that tend to ally with the ideological interests of the justice who's making the decision.
Elizabeth, one of the most prominent debates about legislative history and textualism was the King v. Burwell case, which I think you were involved with and filed an important brief. And there, Chief Justice Roberts joined the 4 liberal justices in upholding, I'm just reading from Rick, in upholding the constitutionality of the Affordable Care Act's requirements that individuals without insurance purchase it or pay a penalty. Describe why Chief Justice Roberts, by consulting legislative history, reached that result and why Justice Scalia dissented.
Yeah, so I was going to say, as someone who frequently represents members of Congress in statutory cases where they're giving their opinions about the meaning of the statute, for example, we represented Senator Dodd and Congressman Frank in a case about Dodd-Frank, because presumably they would know. Similarly, in King versus Burwell, we represented the drafters of the Affordable Care Act and those who secured its passage. And I think that the King v. Burwell case is a perfect example of where sometimes Scalia's desire to make things seem accessible, for example, he notoriously said that originalism and constitutional interpretation were as easy as pie, was oversimplifying. Because the fact is that sometimes you're going to have to take into account context. And it would just be ridiculous to look at a statute like the Affordable Care Act and not take into account the entire purpose and structure of the act. And in that case, it was this very, word-focused way of saying that, this one thing didn't apply, but to apply it that way would have been totally ridiculous. And it's not something that goes beyond the democratically enacted statute to look at what the statutory plan, purpose, and structure is. And so, I think Chief Justice Roberts, as someone who is more of, perhaps not as, someone who has perhaps a more reasonable view of statutory interpretation than I think Justice Scalia would. No offense, Kannon. I know you weren't clerking that year, so I feel like I'm not personally insulting you as a clerk. It was right to say, I'm going to not take a ridiculous view of something that I know doesn't mean what I'm going to put forth.
Kannon, as we've heard, there's a dispute between Chief Justice Roberts and Justice Scalia about whether or not consulting legislative history was the right thing to do. I won't ask you to take a stand on those two positions, but tell us why it was that Justice Scalia thought it was inappropriate to consult legislative history when it came to statutory interpretation, but necessary to consult legislative history and original public meaning when it came to constitutional interpretation, and what the dispute between Roberts and Scalia involves.
Sure. So, first of all, to respond to Rick's, I think, implicit, maybe explicit critique of Justice Scalia as being a man of contradictions, of perhaps using these methodologies to reach favored results, I don't think that Justice Scalia thought of originalism or textualism as these sorts of scientific methods where if you simply input the text of the relevant provision, you would automatically, at the end of applying these rules, get a compelled result. I think he recognized that the law is an art, not a science, and that there are close cases. And I can attest to that fact from having clerked with him and having had the experience of going round and round in chambers discussing some obscure statutory provision where the answer for a textualist was just not easy. There were competing cues in the text of the statute. There were so-called canons of construction that, as Whelan said, point in both directions. And he recognized, I think, that there were hard cases, and he recognized that you could not apply these principles rigidly. And the best example of that, to which Elizabeth just adverted, was the notion of absurdity, the notion that if the plain text of a statute would lead you to an absurd result, that you should not apply the plain text, that you should create an exception. And he referred to himself as a faint-hearted originalist and or textualist, and it was precisely for that reason. He recognized that no set of rules is exactly perfect and that at some point common sense should kick in. And I think that if the Chief Justice had written his opinion in King versus Burwell in that way, if he had said, well, the text seems to have this more limited view, but that result would be absurd, Justice Scalia might have reacted somewhat differently than he did to an opinion that felt like one of those opinions written in 1974, that felt like it was really being written in a way that was unmoored from the statutory text. Now, on this question of the difference in approach between statutory and constitutional interpretation, I think what I would say that probably drives what seems superficially like a methodological divergence is that I think when it comes to statutes, Justice Scalia had a profound faith in the democratic process. His view was that if we could only establish a set of relatively clear rules that discipline the interpretive process, Congress would know that those are the rules by which it would have to play in drafting statutes, and that Congress could go back and amend statutes if it felt that the court's approach was leading to incorrect results. And again, he had tremendous faith and belief in the democratic process. He had a certain skepticism toward legislative history. He felt that it was often inserted by people who had an incentive to put a particular spin on a statute, even if that was not the view of the majority. I suspect that if he got a brief from the good Senator Dodd and the good Representative Frank on the meaning of the Dodd-Frank Act, his reaction would be, well, why didn't you put that in the actual language of the statute rather than telling it to me after the fact? But I think when it came to statutes... Well,
generally it is in the language of the statute, which I would say, I think you are doing a very good job of defending Scalia by saying that his approach is moored in the statute, whereas Chief Justice Roberts is not. I would say exactly the opposite. You don't have something moored in a statute that would read contrary to the entire purpose and structure of the statute. And I think that's one of the things that I find dangerous about Justice Scalia's legacy being described as, this high-minded principled jurist who applied these principles neutrally, because I don't think it was neutral. I don't think you can look at his body of work and say that it was entirely neutral. And I think some of that was a result of, I don't know what processes, but I saw it more later in his career than earlier. I think some of the immigration cases where he kind of parrots these unnecessary attacks on undocumented immigrants, or as he calls them, illegal immigrants in his opinion, are signs of that. And same with the marriage equality cases and some of the race cases. So I just think that there's this mythology around him as this neutral jurist that is very helpful to his ideological ends, but perhaps not an accurate.
But if I could just say one thing in response to that, and I don't mean to be out of turn, regardless of the terminology that you use for people who are in the country unlawfully, it seems to me that it's hard to dispute the proposition that the textualist approach to statutory interpretation is more disciplining of judges than the alternative, a free-floating search for the perceived intent or purpose of a statute. I mean, after all...
That's not in any way what I'm suggesting.
Well, I think it was at least implicit in what Rick said, and I'm happy for you to set me right on that. But ultimately, Justice Scalia's view, again, when it came to statutory interpretation, was that precisely because laws are passed by 435 members of the House, 100 members of the Senate, and signed by the President, it is a very dangerous enterprise to ascribe particular weight to the views of individual legislators or potentially the views of no legislator at all, and that at a minimum, the textualist approach to statutory interpretation is more transparent. Yes, there can be debates about which dictionary you use and which definition you refer to, and again, there can be hard cases, but there is less room for judges to inject their personal policy preferences than there is if the entire enterprise is unmoored.
This is an excellent debate. We have 15 minutes left, and we must now return to the Constitution, because this is the National Constitution Center.
We're going to start the National Statutory Interpretation Center.
No one will come.
That'll have even higher visitation than the National Constitution Center. Rick, for decades, law professors and journalists have called Justice Scalia an inconsistent originalist. When I started off at the New Republic magazine in the early 1990s, I wrote a piece saying that Justice Scalia sometimes betrayed his constitutional methodology, but he deserved respect as one of the few justices who had a methodology to betray. And I think that this book is the most comprehensive effort to bring together the many cases where you assert that Justice Scalia was an inconsistent originalist. And you have cases ranging from affirmative action to gun control, to Citizens United, to voting rights, to Bush v. Gore, to voter ID, and others where you say that Justice Scalia ignored the text and history of the Constitution in order to reach preferred results. That's a heavy brief, but why don't you give the audience the highlights of the most important cases in which you think Justice Scalia was an inconsistent originalist?
Well, first, let me respond to Kannon.
More on statutes. I would just say, for anyone who's interested in this debate and the best counterpoint to Justice Scalia on textualism, I would point you to Judge Robert Katzmann's book. Yes. I think you've had it here. Interpreting Statute. We had a great program. Check out the video of the program. And he puts forward where text is central, but it is not the sole thing that you look at. And it's a more holistic and I think realistic approach that understands the legislative process better than. So that would be my response. And I do quote Judge Katzmann in the book. So on the question of inconsistent originalism, we've heard a little bit from Elizabeth about how, for example, at the time that the 14th Amendment, or right after the 14th Amendment was ratified, including the Equal Protection Clause, one of the things that happened is that Congress passed laws that gave preferences to African Americans. And so what was the original public meaning of the Equal Protection Clause at the time that it was passed? Was that race-based affirmative action
is not inconsistent with the Equal Protection Clause. This is something that Justice Scalia never addressed in his writings. One of his clerks, Gil Seinfeld, who was on the court the year that Justice Scalia faced one of these cases, wrote a memo to him about it and said, here's all of the history that shows this happened. I think maybe you reject the history, maybe the history is irrelevant, maybe you're going purely on text of what the words equal protection mean, but you should respond. And Scalia never responded. And there are many examples of this. Another example, and I heard both Kannon and Ed make the same point, and I hear it a lot from Justice Scalia's defenders, that he simply wanted to defer to the democratic process on questions of abortion or things like that. Well, he wanted to defer except when he didn't. So one example, very important example, is a 2013 case called Shelby County versus Holder. In that case, Congress reauthorized the part of the provisions of the Voting Rights Act for a 25-year renewal. It passed in the Senate by a vote of 98-0 and by a very lopsided vote in the House. Justice Scalia was not willing to defer to the democratic process there. In fact, he said anything that passes by 98-0, he talked about an ancient Israeli body called the Sanhedrin. They would say if it was a unanimous death penalty, it had to be thrown out. Something must be wrong here. And he said the problem here, and he said it oral argument in the predecessor case to Shelby County, is the perpetuation of racial entitlements. So he was not willing to defer to the democratic process when it came to issues of race. And he also was not willing to defer to the democratic process when it came to the rights of gays and lesbians, where he had the view that, and he said this is not me guessing, he said in his cases, he believed that gays had large disposable incomes, so they were a strong, cohesive interest group, and they had too much political power. And therefore, when the state wanted to take steps to go against that, they were going to have a hard time because of the power. So he was not always willing to defer to the democratic process, and his opinions didn't reflect a consistent view of what the Equal Protection Clause meant at the time it was passed. They reflected his values as much as anything else.
Elizabeth, why don't you add to the list some of your favorite examples of Justice Scalia as an inconsistent originalist, and then we'll have Kannon respond to all of them.
We'll give you double time.
I might actually help Kannon out a little bit here.
Since he's the best oral advocate in the country.
Yeah,
I'm sure you can do it.
Yeah.
No problem.
So I first would say that I agree that it is, even though I think he was an inconsistent originalist, I do appreciate that he at least professed a judicial methodology, because for people like me who think he got it wrong a lot of times, we were able to make our case and judge him against what he held himself up to. So every single time we have a race-conscious admissions policy or other affirmative action case, Constitutional Accountability Center always presents that text and history to the court. So they can't say, and I'm glad that the clerk wrote his memo, but they cannot say that that is not something that they were not presented with, and so he needed to grapple with this text and history. So I appreciate that he had a methodology against which we could hold him accountable. Same with Justice Thomas, and I think that there were instances when both Justice Scalia and Justice Thomas have used their original philosophy to take perhaps surprising votes. And I think for Justice Thomas, in some ways, it's actually on preemption, because an originalist view of certain preemption doctrines take very seriously that you can't just have an unmoored search for intent, that it has to be something that's within the context of the language of the statutes. But with Justice Scalia, one of the areas in which I think that he really did follow his originalist principles were in the areas of Fourth Amendment protections, saying that simply because there weren't heat-seeking infrared devices at the time of the founding didn't mean that when they were used by the police in order to incriminate someone, that the Fourth Amendment's protections against unreasonable search and seizure didn't apply. Same thing with jury rights in the Sixth Amendment. He was responsible for a very important case in the criminal defense bar that said that a jury, because of the importance of the jury as a bulwark of liberty to the founders, because of the importance in the Constitution of the jury, anything that enhanced a criminal sentence had to be found beyond a reasonable doubt by a jury. And I know from having represented a lot of criminal defendants that when that opinion came out, this was a huge deal. It was, I think I got a call from the prison before I even knew that the opinion was out, because it was such a, ground-shaking opinion. And for it to come from Justice Scalia, I think, was really important. But I think where he became very inconsistent was indeed on these questions that implicated perhaps the amended Constitution and not necessarily the Constitution as it existed in 1789. And there's absolutely no reason as a constitutional originalist and textualist that the Constitution's amendments, writing in equal protection, writing in voting rights, writing in equal citizenship for women and people of color and people who are of low socioeconomic status, that they are not as much part of the Constitution as the way the Constitution was written in 1789. And I don't think that he gave that enough credence. And I think that is where Justice Ginsburg's taking up the charge of, one might say, progressive originalism really showed his inconsistencies.
All right, Kannon, we've given you a large task, although Elizabeth just made a very nuanced and balanced argument, giving the justice credit for, in some cases, reaching conclusions that diverged from his policy views. But in others, notably, both Elizabeth and Rick have said, when it comes to the 14th Amendment, that's the amendment that promises equal protection under laws. It turns 150 this year. In July, we're going to have a year-long commemoration of this crucially significant pillar of what some have called the second founding. Justice Scalia was, as Rick tells in that quite memorable anecdote, unwilling to engage the extensive scholarship suggesting that the framers of the 14th Amendment not only tolerated race-conscious remedies in some cases, but thought that the amendment didn't apply to political rights under any circumstances. It only applied to civil rights, not political and social rights, which is why some conservative critics have said Bush v. Gore is completely inconsistent with original understanding. So you don't have to litigate the case, Kannon, but why did Justice Scalia never respond to these arguments, and what should we make of the fact that he never responded to or engaged them?
So I can't speak too specifically to the context of equal protection in these laws, though my dim recollection is that the laws could be explained on the grounds that they provided remedies directly to individuals who were victims of discrimination. And of course, Justice Scalia's view of the 14th Amendment as it applies to racial preferences was that there is a distinction between providing remedies to individuals who themselves have been the victim of discrimination and to individuals who are receiving those benefits solely by virtue of their race or another protected characteristic. I think more generally, I certainly would not want to leave all of you with the sense that Justice Scalia's view was that everything should be left to the legislature. He had great faith in legislatures. He had great faith in the people, as evidenced by his muscular view of the jury right. But at the same time, he knew that his job was to interpret the Constitution, and that included interpreting the various individual rights in the Constitution. And he was not at all afraid to do that in a way that would be politically unpopular. And just to very briefly survey the examples, some of which we've talked about today, flag burning, providing the critical vote, saying that flag burning could not be criminalized at a time when that was very much a hot-button political issue. In one of the cases I argued, Maryland versus King, the case under the Fourth Amendment on whether the police could collect DNA from individuals who have been arrested and use that DNA to try to solve other crimes. He held that that violated the Fourth Amendment because the police did not have a warrant, even though literally every single one of the 50 states had filed a brief saying that they desired this power. And virtually all of the states had statutes that he would have effectively invalidated. The list goes on and on. You could name virtually every provision in at least the original Bill of Rights, with the certain exception of the Third Amendment. And Justice Scalia had something to say that often would lead to results that one would never describe as politically conservative results. I think that the exception to that is the Second Amendment. Of course, he will be remembered for his opinion in Heller, the opinion that recognized an individual right to bear arms, and one could certainly say that that is a quote-unquote conservative result, but he reached it through a faithful application of his originalist approach. And what was most noteworthy, I think, about that case was that when Justice Stevens dissented in that case, he joined issue with Justice Scalia on originalist terms, and there was a fevered back and forth on what the framers meant when they included the preambulatory language in the Second Amendment. And I think that in many ways there's no better legacy to Justice Scalia's approach than the opinions in that case, which I think reflected Justice Scalia's ability to set the terms of the constitutional debate.
Great. Well, we are almost out of time in this completely rich and illuminating discussion. Rick, the last word is definitely to you. You've heard Kannon and Elizabeth give their account of Justice Scalia's legacy. In 50 years, will Justice Scalia be remembered? How will he be remembered? And what will his legacy be?
Well, your question is so hard, it's why I almost decided not to write my book. Because I do think that I had a project 5 years ago. I was going to write a book called The Scalia Court, and I was going to make the point that he was the most influential justice. And then I realized it was much more complex than that. In some ways, he was very influential. In other ways, he actually wrote very few majority opinions. Heller and some of the criminal procedure cases are the rare counterexamples. He was such a complex figure. And so one morning I woke up a couple of years ago, and the date was February 13th, 2016. And I wrote to my dean, then Dean Erwin Chemerinsky. I said, I think I'm going to pick up this Scalia project. And he wrote me back. He said, Scalia just passed. It was that same day. I said, well, now I've got to write the book. And so he's just been a figure that's fascinated me. And I think, as you mentioned at the beginning, I think that he is deified in a way by the right that he doesn't deserve, and he is demonized by the left in a way that he doesn't deserve. I do think he was trying to do what he thought was best for the country in a patriotic way of interpreting the Constitution, but in many ways I think his project has failed, and it's unfortunately brought us to a place at a very polarized time where I'm worried that his legacy is going to further pull us apart, both the language he used and the fact that when he used his harshest language, it was to try to argue that the other side's approach was not just wrong, but illegitimate. And I think there's a problem when you start accusing the other side of lacking legitimacy in their interpretation. It's a problem for the judiciary and for the rule of law, and it kind of echoes the kind of things we're seeing today in society. So his legacy was complex. I hope that he will be looked at, and getting us to pay more attention to text, getting us to pay more attention to how things are written will I think is a good thing, but I think it can go too far. So I'm hoping that his legacy will be a positive one, but in our polarized times, my expectation is that he will, to the extent that he is remembered, be remembered by very differently by people on from different political perspectives.
I need to thank our panelists for an extraordinarily rich and engaged and nuanced discussion. And I need to thank you, ladies and gentlemen, for spending 2 hours on a rainy weekday evening educating yourself about this extremely important figure, learning about the details of constitutional and statutory interpretation, and learning about the U.S. Constitution. It's just been a pleasure to share this evening with you. Please join me in thanking our panelists. That was.